Picture this courtroom. A defendant sits at the defense table facing the most serious charge the law can bring, a capital offense, a charge that, if it results in conviction, may end in his execution. His defense attorney has prepared a rigorous cross-examination. She has reviewed every piece of evidence the prosecution intends to use to bind her client over for trial. There is one witness on the stand, a detective. The detective reads from a prepared summary of the case. The victim does not appear, the forensic analyst does not appear, the medical examiner does not appear, the eyewitnesses do not appear. In most American jurisdictions, this is not a failure of the system, it is the design. Tonight, on Words with Wentz, as a paralegal who has read these rules carefully, I want to walk you through a constitutional gap that most Americans have never heard of, and that most defendants facing the death penalty never escape. The federal rule is worth reading directly. Federal Rule of Criminal Procedure 5.1e states, "A finding of probable cause may be based on hearsay evidence in whole or in part." That language was written in 1972. The advisory committee explained why, because a grand jury indictment may be based entirely on hearsay, a rule the Supreme Court established in 1956. There is practical advantage in making the preliminary hearing equally flexible. Read that carefully. The rule was designed to make the preliminary hearing convenient for prosecutors, to reduce the pressure on them to produce live witnesses, to give them the same latitude at the probable cause stage that the grand jury already provided. Most states followed the federal model, California in 1990 through Proposition 115, Utah through Rule 7 of its criminal procedure rules, Florida and Illinois and New York and Arizona, each at varying points over the past 50 years. Not one of them, not one, created a higher standard for capital cases. A defendant facing life in prison and a defendant facing the death chamber are processed through the same probable cause filter, under the same hearsay rules, at the same standard. The Supreme Court has told us more than once that death is different. In Woodson v. North Carolina in 1976, the court held that the penalty of death is qualitatively different from a sentence of imprisonment, however long. In Caldwell v. Mississippi in 1985, the court held that the Eighth Amendment requires a greater degree of reliability when the death penalty is imposed. These are not suggestions. They are constitutional commands. The court has applied them to jury selection, to jury instructions, to appellate review, to the competency of counsel, to clemency procedures. What the court has never applied them to, what no court has ever required, is the evidentiary standard at the preliminary hearing that initiates the capital proceeding. Professor Anna VanCleave of the University of Connecticut School of Law published a detailed analysis of this gap in the University of Illinois Law Review in 2023. Her conclusion, in the absence of clear guidance from the Supreme Court as to the actual meaning of heightened standards, lower courts apply the same standards used in non-capital criminal cases, or even relax rules in favor of the state. The constitutional command is, death is different. The actual practice is, death is processed identically. This is not a theoretical problem, it is happening right now. In July 2025, the preliminary hearing began in Utah for Tyler Robinson, a defendant facing 10 charges, the most serious being aggravated murder, a capital offense. The Utah County Attorney's Office has stated it will seek the death penalty if Robinson is convicted. Before the hearing began, the defense filed a standing objection. The objection identified the specific hearsay evidence the state intended to use. Photographs and video recordings presented without the people who took them. The Utah State Medical Examiner's autopsy report submitted without the medical examiner's testimony, and testimony from police officers discussing statements they received from other officers who were not in the courtroom. Lead defense attorney Kathy Nestor argued that without the individuals who actually made these statements or recorded this evidence, no foundation can be established to determine their credibility, and that attorneys are unable to conduct meaningful cross-examination. Under Utah Rule 7, hearsay is permissible at preliminary hearings. There is no capital exception. The bar the prosecution must meet is described in news coverage as very low. A man who may face execution was bound toward trial on a hearsay record that did not include the medical examiner who performed the autopsy. That is not an aberration, it is the rule. Here is what is actually at stake when a capital defendant is bound over on a hearsay record. When a law enforcement officer summarizes an investigation at a preliminary hearing, that summary reflects the officer's interpretation of the evidence, not the evidence itself. If the investigation was conducted with bias, if evidence was misinterpreted, if exculpatory information was omitted, the hearsay record will embed all of those errors. Without the forensic analyst, the eyewitness, or the medical examiner on the stand, the defense has no mechanism to probe the reliability of what it is hearing. Critics of permissive hearsay have documented what is sometimes called the rubber stamp effect. When hearsay is the primary currency of the preliminary hearing, judges are hearing a filtered version of the prosecution's case. The probable cause standard is already low. When the only evidence presented is the prosecution's own curated summary of its investigation, that standard becomes effectively impossible to defeat. And there is a constitutional blind spot that makes this worse in capital cases, specifically. The Supreme Court's Crawford decision in 2004 requires live confrontation for testimonial hearsay at trial, but Crawford does not apply at the preliminary stage. The preliminary hearing is the one point in the criminal process where the defendant's right to confront witnesses is weakest. In a capital case, the weakest adversarial check in the entire system is applied at the hearing that initiates the proceeding that may end in a defendant's death. I'm not arguing that hearsay should be eliminated from preliminary hearings. The victim protection rationale is real. The Victims' Rights Amendment passed in Utah in 1994 with 68% of the vote, and it was passed for good reason: to spare a living survivor from having to relive their trauma twice, to protect a child witness from the stand, to shield a victim from a second courtroom appearance before trial. That protection still matters. That purpose is still valid. But here is what the 1994 voters could not have anticipated, and what the 2024 expansion of that rule made worse. In 1994, Utah's constitutional amendment to Article 1, Section 12 overrode State v. Anderson, a 1980 decision that had recognized a confrontation right at preliminary hearings and limited hearsay use. The amendment permitted reliable hearsay in its place, in the name of victim protection. Then, in February 2024, the Utah legislature passed HJR 013, expanding it further. Under the amended Rule 7b, a prosecutor is not required to corroborate a written witness statement or call the declarant at the preliminary examination at all. A capital defendant can now be bound over without a single live accusing witness. In a case where the victim is no longer with us, there is no living survivor being shielded from re-traumatization. The medical examiner who performed the autopsy is not a trauma survivor. The detective summarizing another detective's notes is not protecting anyone from pain. The rule that was built to protect living victims does not apply in this situation, and yet here it is, in its most expanded form, in a capital proceeding. The Supreme Court said death is different. In my opinion, a man's life should not hang on a precedent being applied in ways the voters who passed it never intended. And until that changes, every defendant who walks into a capital preliminary hearing walks in with less protection than the Constitution promised them, and more at stake than any hearsay summary can fairly represent. What are your thoughts? Should a capital defendant face the possibility of the death penalty on a detective's summary, in a case where the original justification for that rule no longer applies? Leave a comment below. The documents are in the description. This is Words with Wentz. Know your rights.